Hi, my name is David Shapiro. I'm a San Diego-based criminal defense attorney. Today I'd like to discuss with you being under the influence of a controlled substance. Generally speaking, these offenses are prosecuted under Health and Safety Code section 11550. And we usually see a situation where the cops are called for whatever reason, whether there's a disturbance or someone exhibiting what they believe is erratic behavior, and sort of like a DUI, but not really, where a field sobriety test and a DRE, a drug recognition expert, will be to conduct certain tests on that person to see whether or not their ability to basically take care of themselves in public is impaired and they're a threat to themselves or to others. So usually you'll see their pulse will be taken, their heart rate, their pupils, whether or not they're dilated and in what measurements, all those types of things, whether or not they're sweating. You hear about white foam on the tongue and all this nonsense a lot of times that certainly could be explained alternatively in reasons that have nothing to do with being under the influence of a controlled substance. But you see the prosecution and their experts usually come in and harp on these things. Usually on these 11.5, it's usually a blood or urine test that comes back with results that indicate what was alleged to have been in that person's system, whether or not it was a consensual blood draw, whether or not it was a warrantless blood draw, or whether there was a warrant. All those factors go into what we can work with and trying to keep certain pieces of evidence out of the case. Certainly, if we were able to be able to suppress a blood draw or a urinalysis in a case like this, the prosecution would be shorthanded. They wouldn't really have a lot to work with. These offenses, the law, at least generally requires certain mandatory conditions. It's kind of weird how they give you a 90-day custody or alternatives to custody, those types of things for a simple being under the influence of a controlled substance that doesn't involve driving, yet you could have 2-3 DUIs and still get no more than 120 days sometimes as the minimum sentence. So it's a unique and evolving area of the law, Health and Safety Code 11550. Legislature has been slow to respond to not decriminalizing, but minimizing the amount of punishment for these types of offenses, but it's definitely something to be taken seriously. If convicted, you're placed on probation. Usually are saddled with a Fourth Amendment waiver, usually have to register as a narcotics offender for a period of time. So definitely something to be taken seriously. These cases are winnable. They can be won. Evidence can be kept out. You just need to have the right set of facts and equally, if not more important, the right attorney.